May it please the court. My name is Geraldine Gamilla, and I represent the appellant, Indra Adusamili, in this case. May I reserve 2 minutes for rebuttal?
You may.
We are here today to ask this court to reverse the grant of summary judgment below. This was incorrect because the appellant raises a genuine issue of material fact as to her claims on national origin, harassment, and retaliation. But before turning to my first issue, as a procedural matter, I would like to note that this matter comes on a Rule 56 motion of summary judgment. Here, the defendant bears the burden of establishing that the appellant has no genuine issue of material fact. However, the defendant fails to do so because there are multiple disputes of fact and credibility in our case. Turning to the first issue. The defendant has harassed my client because of her sex and national origin. It subjected her to humiliating comments from supervisors and coworkers that were emotionally painful for her and also stigmatizing.
I think there's no question that your client makes out the first prong because she did complain at least once.
Yes.
But I am concerned that the comments here are not objectively harassing, that they don't rise to the high level that we set in the Silk case, which was also a police department matter.
Yes, Your Honor. So I would say that the conduct here is especially objectively hostile because a reasonable person could find such comments that were made towards the appellant harassing. For example, before June 1994, Joe Cannon told Adusamili not to stand in front of the police department and wave at people because she would look like a prostitute. And at some point before January and September 1994, they told Zelius told Adusamili to break a banana in half. And
well, that one's kind of ambiguous. I agree that the one about Indians smell bad because they eat spicy food. The comments here are definitely ugly. But are they because this is hazing by police officers of civilian women who are put into the district? Or is there enough here to show that it rises to a violation of Title VII?
I would say that it does rise to a violation of Title VII because, for example, she was asked specific things about being an East Indian woman, like someone has asked her if Indian men use deodorant or perfume, and this attacked her sense of personal dignity. And in general, as you stated, the spicy foods comment made her feel uncomfortable, and being in a workplace, not being able to eat the types of foods that you are comfortable with and used to could be very difficult and also embarrassing.
But most of these folks were co-workers, except for the immediate supervisor, Zelius. And we've set a really high standard for when Title VII is violated. That in Silk, the captain joked that he was going to put a bomb under the guy's car, and this court said it's simple teasing. So how is that different here?
I think that it is different because they specifically discriminated on her due to her race and national origin, as well as her sex, which is what Title VII bars under Morgan versus SVT. And also, there were different things that they did that constituted them failing or refusing to hire or discharge her. So, for example, they placed her after she made her sexual harassment claim in January of 1994, just right after they finished this investigation. In March 1994, they immediately placed her in a behavioral alert program, indicating that they didn't want her to make these harassment claims because...
Well, they're about to argue it's because the new commander, Byrne, came in February '94, and as they say, the new broom sweeps clean, and she was gone.
Okay, yes, Your Honor. So another reason that this is problematic is because Commander Byrne was later replaced by Supervisor Zelius,
Well,
and
I think what the record reflects is in December of '93, they hire a civilian supervisor for the first time.
Yeah.
Your client believes she should have gotten it, and then that woman, Zelius, became her new supervisor. But the city's gonna argue that in February, a new commander comes in, and he has, if they were willing to put up with it before, they aren't any longer. So what do you say about that?
I would say that the issue is it's not only the commander that was engaging in the sexual harassment or the discrimination. There were actually different coworkers, and she has actually expressed this concern before. She has brought to her supervisor's attention that she thought someone was sabotaging her desk, but actually her supervisor at the time didn't. He said that there was no reason for anyone to be sabotaging her desk, and he took no further action because he believed that nothing problematic was occurring in this case.
But she says that she admits that the commander, Byrne, was not biased, had no prejudice against her. So how do you tie these coworkers and low-level supervisor Zelius to Byrne's decision to transfer her out and to put her in behavioral alert?
Yes, Your Honor. So actually, right before she was terminated, Commander Zelius was the one that wrote the memorandum complaining of her behavioral issues and such, as she was closely supervising her, and this ultimately may have biased the commander's decision to terminate her because of what he was hearing from that report.
So it's like a cat's paw theory, is that what you're saying?
Yes, I believe that everyone in the workplace, or not, a lot of them were in this together trying to push out the appellant because she wasn't a part of of what they're normally used to. The police department is heavily male, and also a lot of them are white, and she's different, of course, because she's of East Indian origin.
But if, sadly, she were being hazed because she's a civilian and the police officers hate civilians, that wouldn't violate Title VII. There's got to be more. It's got to be based on a protected category.
Yes, so I don't recall the department or the employees making remarks or actions towards her because of her level of expertise.
Okay.
She actually had a higher education than the supervisor,
Yep.
Zelius, that got chosen to be promoted over her.
Yep.
And she also did many of the same duties as the police officers.
Mhm.
I think it was approximately 50% of the same duties. So they had a different title, as she was a civilian and they were police officers.
Wasn't she just a bad cultural fit? She was perhaps overeducated. She was well educated in going into a district where the officers, most of them at that point in history, didn't even have a college degree, and she was replacing people so that they had to go out on the street. That's sort of a guarantee they're going to hate her, and I'm not sure that kind of hazing by officers rises to a Title VII violation. Is that how you read what went on here?
Oh no, I think it was beyond mere hazing. For example, there was a complaint where, for her sexual harassment complaint specifically, she complained that she was touched in the left buttocks, and that different supervisors and coworkers were staring at her breasts and also attempting to make eye contact with her at the same time, trying to make her feel uncomfortable in her workplace. And that also brings me to another point. When she complained about her harasser, Gray, he was moved to a desk that was right next to her. Actually, it was only 5 to 10 feet away from her.
Well, she made the complaint in January, and the department did a full-on internal affairs division investigation and found nothing. And then in July, they say they had to move him temporarily a few hours a day to a desk near her for his own work. is that such a bad choice as to deprive the city of an affirmative defense?
I would say the issue is more than just moving him and the desk that was close to her. It's also that when he started working next to her, she would also talk to her supervisors and say, well, he's making me feel uncomfortable because he's staring at my breasts, he's trying to make eye contact with me, but nothing was done even after the investigation was closed. She still had other complaints and nothing was done about that either.
But she admits by that point she's no longer complaining. She went off to the EEOC, but she stopped complaining.
Yes, the appellate actually stopped complaining because she just felt like helpless because no one was helping her within the workplace, and she didn't know who else she could go to because she felt like they were all this intertwined family, and that if she complained more so than she already did, they would work together and do something further to retaliate her, such as putting her in the behavioral program and then immediately lowering her evaluations. They were actually all good evaluations until right when she was placed in the program, which was shortly after she complained.
Actually, they were good even later. I think she had good evaluations until 2 months before she was fired. So even when they were putting her in behavior alert, she had just gotten a good evaluation in February, the month before. What do you make of the timing here in terms of the retaliation count?
I think the timing is just way too close. For example, first of all, they placed her in the behavioral program that's usually for problematic police officers, and she didn't do anything that would raise to the level of drug abuse or engage in domestic violence. And other than that, just being put in it only immediately after reporting, and then after that, once she did get terminated, the city claimed they didn't know of the EEOC complaint, but then they found out about it right after she got fired, which is, it just seems like they did know about the complaint at the time.
What do you make, I guess I've asked a lot of questions. Are there any other points you'd like to make?
I guess, yeah.
I don't think we've touched on the promotion yet. I think there's also she claims that the city denied her promotion because of her national origin.
Yes, Your Honor. So she spoke with her supervisor about being promoted to the supervisor position, and since she had so many good reviews coming up to that date, she thought that it was basically a shoo-in for her, and which is why she applied verbally to her supervisor and didn't think that she would be denied, and was surprised that she was replaced by someone else in the end. Your Honor, I see that my time is up. May I briefly conclude?
Yes.
As a matter of public policy, just to allow an employer...
So when the time's up, all you get is the prayer.
Oh, okay. Sorry. For these reasons, we ask this court to reverse the decision below and allow my client to make her case to a jury. Thank you.
Thank you. You are welcome to ask questions. I think at this point, you'll see this is a very simple case. It comes down to are the facts bad enough? Good afternoon.
Good afternoon.
Morning.
Good morning. May it please the court. My name is David Reyes and I represent the city of Chicago. We are here today to ask this court to affirm the grant of summary judgment. That grant was correct because the plaintiff has failed to raise a genuine issue of material facts as to the claims of national origin, harassment, and retaliation. Before I turn to the first issue, I'd like to note that as a procedural matter, that this matter comes to the city's Rule 56, motion for summary judgment. Plaintiff bears the burden of establishing a genuine issue of material fact, and she has failed to do so here. Accordingly, the defendant is entitled for summary judgment as a matter of law. First, turning to the first issue, summary judgment should be granted as to the national origin claim. The plaintiff cannot present any direct evidence and therefore must proceed under the indirect burden shifting method set out in the McDonnell-Douglas case.
But I think that there's no dispute from, that she's in a protected class and something adverse happened to her, she was fired, so we're down to two prongs. They argue she wasn't working up to legitimate expectations of the city because she's making all these mistakes. How would you respond to that?
I would respond that a lot of the mistakes that she committed actually had major consequences. Some of these consequences were police officers missing court dates, being sent on the wrong days, and for us, the city, that it was a huge reason for us not to, or it was a legitimate reason for terminating the.
But if she were really that bad, why do the supervisors keep giving her good evaluations until 2 months before she's terminated?
Your Honor, those evaluations that were good were sort of in the beginning when she was working there, and these evaluations were sort of just a way to push her to keep doing well. And also, most employers, especially here in Chicago, we give employees about 60-90 days to
Sure.
Adjust.
Sure,
So,
but this is 2.5 years. It's past, well, it's 2 years. 2 years of good evaluations. That's past probation. How is she to know that she was supposedly performing so badly?
so that we actually we did give the plaintiff a lot of feedback. So whenever she did make a mistake, we would try to reach out to her, help her out, but she was very she wasn't cooperating. It was hard for her to receive criticism. So, and we would give her criticism and tell her that there's some certain things to be done, certain or things that needed to be filed a certain way, and she kept failing to do so. She would blame others, or she would not take responsibility for her actions. And for us, that was something that we saw that she really needed to fix, but over the 2 years, she never ended up fixing that.
But you didn't, but there's no change for her until January of '94. She makes a complaint about sexual harassment, and in March, bingo, she's suddenly in a disciplinary program, and the commanders requested she be transferred. I mean, what do you make of that timing?
I think that the timing here is it's a coincidence, but I don't think it has anything to do with that. It was more
Well, what happened in the meantime between January and March?
Right. So during that time, she filed things incorrectly, and we saw that she really needed to be put in a program where she could learn and perhaps improve on her.
Did her supervisors ever write her up for any of these mistakes? What kind of notice exactly did she get before she was put into this disciplinary workshop?
I believe she was given informal warnings. I'm not sure if there's anything on the record that was
Informal as an oral warning?
Oral
She was
warnings.
never officially written up before she was put into this program for problem officers.
I think that there might have been some formal warnings as well, but even so, she continued to keep making the same mistakes over and over.
But Counselor, wouldn't you say that this work environment that she's in is partially the reason why she's having trouble taking criticism and having trouble doing her work accurately? I mean, put yourself in her shoes.
I think that you do make a good point, Your Honor, but in this case, it wasn't like that at all. We actually a lot of times we would give her a lot of feedback and try to help her out, and that was the main thing that we always did. Is every employee, we want to make sure that they're meeting the expectations that we want, and we would give her effective criticism. But even so,
Well, I mean, how effective is the criticism if she doesn't even seem to be aware of the fact that her supervisors were having these issues with her work? That doesn't seem very effective to me, and it kind of makes her. It's kind of like plays down the argument that she wasn't meeting these expectations if she didn't know that she wasn't meeting them to begin with.
And I think that's why we decided to place her in the behavior alert program, because we decided that she needed to take a step back from everything. It wasn't any punishment at all. It was more as like we really wanted her to succeed and overcome the things that she wasn't
The
succeeding
problem is that you said we wanted her. Their argument is it's a cat's paw theory that you've got a new commander who came in and he doesn't know her from Adam. So the immediate supervisor, who's one of the harassers, sends him a memo saying Dusamilli's an awful employee, and that's when he puts him puts her in the behavior alert. So her argument is that we, the supposed decision maker, isn't really the one driving this argument. It's the coworkers.
Your Honor, the plaintiff cannot argue a cat's paw theory to explain a causal nexus here, because a cat's paw theory requires that a non-decision maker exercise such singular influence over the decision maker, and that the decision to terminate was a product of blind reliance, and that's citing Staub versus Proctor Hospital. However, that was not the situation here, because Commander Bryan began supervising the plaintiff in February 1994. The plaintiff had never alleged that Commander Bryan was ever biased against her, though he was informed that by Zelius.
I know
That
he was informed by Zelius, and to beat off a cat's paw theory, you got to show he made an independent, objective decision.
Right. The city had a strong affirmative defense under any formulation of the cat's paw standard of a chain of causation, and it can be broken if the unbiased decision maker
Made an independent investigation. So where is the independent investigation by your new commander, Byrne?
So when are you referring to the investigation when Gary was?
No, not the IAD investigation. You just said that when Byrne came in, brand new supervisor, he was informed by Zelius. But Zelius is one of the alleged harassers. So I want to know, does Byrne did he have any independent observation of his own?
Yes, I think since he had his own thoughts on this, and he ultimately concluded that.
How so? How did he have in 3 weeks have any objective basis to decide she was performing badly?
Right, so during the time that Commander Bryan was there, he actually noticed right away that there was a lot of court misfilings. Officers were missing their court dates, being sent on the wrong days, being sent on Saturdays, which that doesn't make sense. And for that reason, Commander Bryan, he believed that it was justified termination here for that reason.
Why did he wait until after the IAD investigation was closed? I think it was like days after they closed that sexual harassment investigation. He requests that she be moved out.
Your Honor, are you referring to I think the claim that was made about her I think it was made after her termination, if I remember on the record. Or are you referring to the?
I'm just asking about the timing of a lot of things, because her retaliation claim is based on timing. What do you consider the relevant timing here to be?
I think that the city here, their theory, or not their theory, but our argument is that throughout her time here, the plaintiff has never been a strong worker from the beginning, and it started to show. And then as soon as the old commander left and then the new one came in, he saw that he wanted to make new changes because he's a new supervisor, and he immediately saw that the plaintiff here was not a good worker, and he believed that termination here would be justified for that reason. So that's the city's argument, and this is how we see the timing of things.
But why does her evaluation go down only 60 days before they fire her?
I think as soon as Commander Bryan came in, if I remember correct, in the record, he wanted to make sure that he was on top of things since he was a new commander. So when he was going through everything, he saw that immediately the plaintiff here was misfiling records right off the bat. So that was a red flag for him. And ever since then, he wanted to keep a close eye on her just because he wanted to make sure that this worker was doing things.
Why did he move the alleged harasser right back next to her in July?
Right, so from the reason why he was moved there was because during that time there was only one computer left, and the only computer that was there was right behind the plaintiff, and for that reason Gary, he needed to do his work, so he was placed there temporarily. But
Was it not possible for them to just move the computer further away from her?
So it was only a temporary situation. So any harassment that claimed that the plaintiff did make was taken very seriously. In fact, we made an investigation, and in the end, nothing was found. But
I mean, what was the extent of the investigation?
so I think it was a time period where there was investigations, interviews made, as far as they made sure that they talked to all the people, all the different parties that were involved in there, and ultimately.
So the alleged harasser and the plaintiff, is that the only two parties that were spoken to?
I think on the record, it also states that they talked to other officers just to make sure and see if there was anything going on, but nothing else was found as to that. But as I said before, that harassment claim, there was nothing found, and it was taken very seriously.
And after this investigation was conducted, Counselor, when was she fired?
So she was fired right around whenever Commander Bryan came in. So once he came in, he saw that the plaintiff here wasn't meeting her wasn't meeting the expectations that the city wanted.
So, Counselor, was it a temporary solution because you knew you were going to fire her eventually?
No, it wasn't. Your Honor, it wasn't a temporary solution.
Counselor, you said that it was a temporary solution.
Excuse me. For Gary, yeah, he was put just only in there because he needed a computer to work on. But then afterwards, he was moved somewhere else just to make sure that no further conflict would occur.
When was he moved somewhere else?
Sorry?
When was he moved? Somewhere
2
else?
months before she was terminated.
2 months before she was.
Right, and that was also around the time when Commander Bryan was also just moving in, so he was there, and he's the one that ultimately made the decision to terminate the plaintiff here.
We've asked you a lot of questions. Are there any other things you'd like to add?
Your Honor, I see that my time is up. May I briefly conclude?
Certainly.
For all these reasons, we ask this court to affirm its decision on the grant of summary judgment. Thank you.
Thank you, Counsel. Any rebuttal?
Yes, Your Honor. On rebuttal, I just have 2 quick points to make. Even if the appellant Adusameli did make mistakes here, it was due to the toxic environment that she was forced to be in and couldn't escape despite all of her pleas for assistance. Also, there are multiple disputes of fact here that must go to a jury and cannot be determined before going before a jury.
Like what?
The disputes of fact that some of the supervisors say that different comments or touching the appellant in the left buttocks or caressing her arm didn't take place.
Right, they deny all of them.
Yes.
But what they're arguing is, even if it's true, even if all these things took place, she only complained about the first stuff, the touching on the buttocks, never complained about the rest, and they got an affirmative defense to any liability, because they didn't know.
Your Honor, she actually has spoken to Zelius about complaints of racial discrimination. She has told her that she overheard coworkers saying that Indians smell bad, and they smell bad because they eat spicy food, and it almost feels like they were saying this stuff intentionally right in front of the appellant's face, because they were trying to work together to make her feel so uncomfortable that she would almost want to weep and take herself out instead of them having to do it. But then when that didn't work, they ultimately decided to terminate her. And
And close, give us your prayer, and get out.
for these reasons, we ask the court to reverse the decision below and allow my client to make her case to a jury. Thank you.
Thank you.